And, Your Honor, you did not have the opportunity to hear what Judge Curley did on prior motions as far as Mr. Brennan's life, and I'd like to share some of that because that is important in sentencing. Brennan was 25 years old at the time of the shooting. No prior criminal history or involvement in crime. In fact, his life, which I'm going to outline, was totally devoted to education, advancing his education through college and through special licensing, and his career. His life was filled with just that. Prior to December 9th, his education included boarding school for his high school years, attending and graduating from NYU on a full scholarship. He was a serious student, had serious ambitions. He graduated with a dual degree in economics and Japanese studies, and while still a senior in college at NYU, he was offered an internship with the Murderous right in the city. After graduation, the internship he did so well turned into a career, with Mr. Brennan being a financial advisor. This was all when he was in his early 20s. He studied and tested for and earned very difficult licenses to get. The Series 7 and Series 66 licenses, and he also passed the rigorous CFA exams, and he's a CFA charter holder, and it's only 12% of the people that take it pass it. Mr. Wakey, prior to this date, excelled in his career. After this date and this tragic event, he lost his job and his career with the Murderous. Your Honor, the state has presented no evidence based upon Mr. Wakey's history prior to December 9th, 2021, which would in any way suggest or support that he is violent, criminal, or murderous, or a danger to this community. There's nothing about his history since then which supports any argument that he poses any threat to the community or to others. In fact, Johnny Sage, his partner of 4 years, gave you specific examples of how involved and giving he was to the community and still will be when he gets out of prison. Importantly, Your Honor, there is no evidence that you've heard through this long hearings and trials and through argument today to support that this incident, which resulted in Colton Wright's death, and the circumstances that Brennan was in, was not a singular, isolated in time, but tragic event. Anything that would be repeated at all. Mr. Wakey's defense during trial was self-defense, and during stand your ground, self-defense. And he still continues to believe he had no other choice in those circumstances. That was his belief. The jury did not come back with self-defense, but his belief, again, perhaps it was imperfect, but Your Honor, look at everything he did and worked for. Is he going to lightly fire a gun at someone? Is he going to lightly throw his life away? And we contend that everything that Brennan was and is supports that he would not do this, but for believing that he had to. The court heard testimony during trial, particularly from Nick Trail, as well as Dr. Vega. There was evidence, substantial and competent evidence that would support self-defense. And again, the jury came back with a manslaughter, a lesser, but there was plenty to go to the jury that it was self-defense and was justified. And the facts that you heard during trial, Your Honor, we believe support there's a basis for downward departure. Downward departure under 921-0026, and we'll start with F. The victim was an initiator, willing participant, aggressor, or provoker of the incident. Your Honor, the state stood here today and testified, or, well, argued that there was testimony that Colton rebuffed Brennan at some point, that they had a confrontation prior to that time, and that he was swigging tequila. There was no evidence of that during trial. What there was, and I've carefully gone through Mr. Trail's testimony. Again, Colton Wright repeatedly called Brennan Wakey to join Nick Trail, so there's no evidence that he went over there with any bad will or knowing that there was confrontation. Nick Trail indicated that prior to Brennan arriving and after he arrived, that Colton Wright smoked methamphetamine from pretty much the whole time, and Dr. Vega testified that Colton Wright had a very high level of methamphetamines in his system, as well as metabolized amphetamine. And he described that as being a result of having been smoking meth for a while and it metabolized into another substance. You know, there's no question what everything that we've heard about Colton Wright's childhood and his childhood friends and the letters that we've read that he was positive and light. That's why Brennan chose to get with him, and he saw that in him. And when he wasn't that way, he hoped his help would get him back to that. But the problem is, Your Honor, his methamphetamine use turned him into a monster, and he was a monster that night. Dr. Vega testified, and that's something that we weren't there, that Brennan had to deal with. A methed up guy who was as angry and aggressive, these are Nick's words, as he's ever seen him. Nick Trail testified during trial that he saw Colton Wright holding the glass margarita bottle over his head while moving aggressively towards Brennan. That was participant, aggressor, or provoker. Colton circled around the area with the bottle and circled in a small area in front of Brennan. And you were able to see pictures of that area in front of the bed near the bathroom door before the partition, and circled in the small area in front of Brennan, who was sitting on the bed. You heard, I mean, one of the state's questions to Dr. Russell is, you know, why didn't he leave? There's no question he couldn't leave. Nick Trail confirmed that the only opening out was past the partition to the door, and that Colton Wright was swinging the bottle and in that area, and to get out, he would have to go past him in the swinging area. That's the state's witness. Nick Trail testified that Colton moved from side to side and forward and backwards towards Brennan, who was sitting on the bed while swinging the bottle. That's an aggressor, that's a willing participant, that's a provoker. And the state said, you know, there's no evidence to suggest that Colton was near him or over him because there wasn't blood all over the place. And we heard from Dr. Vega saying that the wounds in the face indicate inches or up to 1.5 feet, and we heard Nick say that Brennan, and there's a typo, Your Honor, I'm sorry, page 5D, it said he swung the bottle, that he was less than 2 feet from Brennan when he swung the bottle over his head. Brennan held, this is testimony from Nick, held and pointed his firearm at Colton only after Colton came towards him swinging the bottle. Importantly, Colton did not retreat or stop advancing towards Brennan after he saw Brennan holding the gun. And Colton's father and stepmother's letter indicate that's what you do. You know, hold it to get someone to stop, not kill him. He did. He held the gun right here, and Colton didn't stop. And I'm convinced that's because of the level of meth in his body. We heard from Dr. Vega that it can make you paranoid, aggressive, not know right from wrong, certainly not have any good judgment, and violent. What is so important, and I know that nothing will change the family's feeling about Brennan, but importantly, Colton said to Brennan, "Shoot me, just shoot me." And Mr. Trail testified that Brennan did not want to shoot him and did not shoot Colton after he said those taunting words. He only shot him when he kept coming towards them and was standing less than 2 feet away. Nick Trail indicated, and Nick Trail was Colton's friend, so it's not like he was saying something, to make it better for Brennan. He said the facts as he remembered them. That Colton was what he thought was trying to scare Brennan or make him flinch and look like Colton was going to hit him. Your Honor, all of this goes toward, is competent, strong, meaningful evidence to support that under subsection F, which is a statutorily mandated downward departure, that Colton was an initiator. He was swinging the bottle. He was a willing participant. He was not stopping. He was actually going forward, coming back, side to side, aggressor and provoker of the incident. Going towards, the state argued that this was an intentional act by Brennan. I don't think the jury found that, and Nick Trail indicated that before shooting him in that instant and after shooting him in that instant, he had the gun down and his eyes were as wide as they could possibly be. He thought he was in shock. That is not someone who was really happy and gleeful about killing someone. We do understand the grief that Colton Wright's family feel. We're people that have lost people, and sometimes in horrible ways. We do. But, they talked about Brennan being, free and living his life for 4 years. Again, he was on a monitor. And you heard how, even on a monitor, he gave and gave and gave and did and did and did for people and didn't bring them down. But Mr. Wakey also has to live his entire life knowing that he caused the death of someone that he cared very much for. Would never have done that if he felt like he had to. Believed he had no choice, but he also has to live with, Your Honor, the knowledge that his entire life that he worked for, including the loss of his career, the loss of his good reputation through the press, and all of the efforts made with the press to malign him and his reputation, and ours as well, but it's Brennan. His actual freedom, Your Honor, is forever altered, changed, or ruined. And we would ask that the court consider those losses that Mr. Wakey had suffered and will always continue to suffer all of his life. We also believe, under mitigating circumstances, that Brennan's capacity to appreciate the criminal nature of the conduct or to conform that conduct to the requirements of law was substantially impaired by the acute stress that he was feeling as he was just trying to save his life. He wanted to get out of there, he couldn't. And Dr. Russell testified to all of that, including that it's just a primary save yourself, I've got to get out of this, that fortunately most people don't have to deal with, a life-threatening, what are you going to do? And you could talk to 1 million women that have been raped, and every situation is different. 1 million people that have been trying to be killed, what did they do? Did they submit? Did they act out? Were they frantic? Were they calm? Were they not? Nobody knows until they're in there. But again, there was substantial evidence that he was indeed having an acute stress disorder, and this is pursuant to subsection C of this downward departure, or he wouldn't have shot the gun. He held the gun before. That didn't stop Colton. He begged. wouldn't stop Colton. He couldn't get out of the room, wouldn't stop Colton. Colton came on and on and on and on. And also knowing how Colton was on methamphetamine, and he was very much on it that night, that he was not going to use any judgment himself. Those are the things that were in his head. We weren't standing there, but you've heard about him. And he just acted. And that included, leaving when he did. Did he do everything right? No. I mean, it's not the law to stay, I don't think, to stay and report a crime. A lot of people do, some people don't. And that action and wanting to get out of the situation, he wasn't really thinking of the best option then. He was undergoing that stress disorder. Your Honor, we'd also argue one that is not statutorily mandated, but we would ask that you consider that the statute is really a non-exclusive list of mitigating factors. And the court can consider it if it is consistent with legislative sentencing policy. And we would argue, Your Honor, that Florida has a very strong stand your ground law, as well as justifiable use of force. While the court did not grant our stand your ground motion or the JOA, and the jury did not come back, again, I would argue, and I think the court would agree, there was ample and plenty of evidence to support self-defense, and that it was a self-defense defense, although the jury's verdict found it to be imperfect, that you consider that. This is not a case in which someone did a drive-by shooting. This was not a case in which, it was a bar fight. This was a case in which someone was swinging a bottle, whether you think that's sufficient or not, at Mr. Wakey, and he acted in self-defense. That is something that our state and our country supports, that we have a right to defend ourselves. And so we would ask for that imperfect evidence that the jury did not find was sufficient to be considered, that this was a self-defense case, and quite unlike most second-degree murders. Well, that's what they started with. So we would ask that you consider that, and also consider that under those circumstances and everything that you've heard, this isn't someone who's dangerous to society or is going to hurt anyone again. Hopefully he'll never be in a situation where he feels his life is at risk. But he's a community giver, not a community menace. And yes, we know that Colton died, and we know the grief of the family, but would ask that you take that into account with everything that Mr. Wakey is, and find, based upon the evidence, that doing a downward departure is, and I believe the language is, weighing the totality of circumstances, which is huge and heavy, I understand that, but make a determination that a downward departure is the most appropriate option for Brennan Wakey for manslaughter in the circumstances that he was in, the circumstances of his life before, no criminal behavior, the circumstances since this occurred, who he is, and is it necessary to imprison him for the amount of time that the state is asking for. And we submit it is not, and you consider that that's not appropriate. Thank you.